Hi everyone, welcome to the virtual amicus, and I am Jay Lodha. So today's topic for discussion would be on how to build a successful litigation practice at National Company Law Tribunal. Now we all are aware that the central government had notified National Company Law Tribunal under Section 408 of the Companies Act of 2013 with effect from 1st of June 2016. Now what is an NCLT? It is a quasi-judicial authority which is incorporated for dealing with corporate disputes of civil nature that are arising out under the Companies Act. However, difference could be witnessed in the powers and functions of NCLT under the previous Companies Act. So the constitution of NCLT as a single forum to deal with company law matters was a welcome move to various stakeholders because it was aimed at providing speedy and expeditious disposal of matters. And also, in addition to that, it had also helped in taking off the overburdened high courts, the load from these high courts. So today, for this very special segment, we are joined by a very dynamic counsel. We are joined by Mr. Ranit Basu, and just to give you all a brief introduction about our amicus for today's session, Mr. Ranit Basu is a law graduate from Bharati Vidyapeeth New Law College, Pune. He began his career in 2015 at the chambers of Mr. P.M. Chatterjee, Senior Advocate. He has been a part of various high-stake matters relating to direct and indirect taxation, arbitration, insolvency, bankruptcy, securities laws, real estate laws, municipal corporation, and cooperative society. He has established a robust insolvency and bankruptcy practice where he assisted clients in recovering their outstanding dues as well as defending claims or advising them through every stage of insolvency and bankruptcy court. He also specializes in matters pertaining to security laws, real estate laws, admiralty laws, and intellectual property rights. He also frequently appears and puts an appearance before National Company Law Tribunal, the Securities Appellate Tribunal, and various high courts across India. He has also represented his clients in high stake arbitration matters in India as well as in Sri Lanka. And you can also reach out to him at ranit@bridgeheadlaw.com. So thank you so much, Mr. Basu, for taking out time from a busy schedule. You know, the council at Bombay High Court is always busy, and today you took out time for this very special segment. So it really means a lot to the entire team here at Virtual Amicus. Anything that you wish to say before we start with our segment?
Thanks, Jay. Thanks, Jay, for having me here. And I feel extremely humbled by your invitation, and I would hope that today's session of whatever I'm going to speak about helps all your viewers in getting an idea about NCLT commercial practice in general, and it also helps them in trying to decide whether or not they want to practice in NCLT on various laws which are being dealt there.
Thank you so much, Mr. Basu. There, over to you.
So, very good evening. In brief, if I would like to, before beginning my session, I would like to say that the practice in NCLT is something which primarily deals with respect to commercial disputes, and it also has there are two laws which are primarily the courts are concerned with while deciding the issues at the hand. The first one being the Insolvency Bankruptcy Code, and the second one being Companies Act. Now, in Insolvency Bankruptcy Code, as we know that it is a relatively new law, and it is still a developing law, which was since the last 5 years it has been there, and even now in the recent apex court decisions, the law has evolved tremendously. So now what has happened is that when it comes to the first part of my presentation of Insolvency Bankruptcy Code, in Insolvency Bankruptcy Code, it primarily deals with with respect to effective resolution of corporates and companies, and the code mandates initiation of corporate insolvency resolution process. So at the first stage, what happens is that if there are three kinds of people who can file their cases before the Honorable National Company Law Tribunal. The first one being the person who has defaulted and whose liabilities are more than his assets. He can himself voluntarily come to the tribunal and file for self insolvency. The second one being the financial creditors. It is being the banks or NBFCs, there is a financial debt involved. And the third being the operational creditors, where the creditors have provided goods and services for which the amount due to them has not been paid, on account of which they have filed these cases. So initially what happened, the idea of ushering in the insolvency bankruptcy code was that earlier there were a plethora of laws which existed with respect to effective resolution of companies, which being say and uh, due to existence of a wide variety of laws, a lot of confusion prevailed, and the purpose of enacting those laws could not be fulfilled effectively. In light of that, the entire system with respect to corporate insolvency resolution was revamped, by way of which the IBC code, with an intention of having a comprehensive code, was brought in by the legislation. And on account of this comprehensive code being brought in, all the issues with respect to corporate resolution came under the umbrella of IBC. Now, in IVC, the first thing happens is that, as I have already discussed, that the three categories of people can file their cases before the National Company Law Tribunal. So, at that point of time, it needs to be considered that the proceedings before NCLT under Insolvency Bankruptcy Code are summary in nature. So the nature of argument and the manner in which the case is presented is where you have to establish that there is a valid debt which is there. So one thing that is of utmost importance is that all the documentations needs to be done in an effective manner, and the court primarily concerns in itself with the fact that the jurisdiction is correct, it is filed within limitation, and the documents establish that a debt is due and payable to it. So on account of that, on a practical aspect, if I bring my approach to you, it is that you do not have the liberty to go into lengthy arguments. You have to establish that there is no dispute prevailing with respect to the debt owed. Initially there was a lot of a lot every time high stake matters came up before the honorable tribunal. There were a lot of confusion with respect to what is the exact definition of dispute. That came to be clarified by a landmark judgment of the Supreme Court, named Mobilog's judgment, in which it was what the definition of dispute has had also been clarified. And broadly, if I bring it before you briefly, then dispute means something that where it is established that the debt is due, and it is established that the debt is not due on account of there being certain drawbacks in the transaction that is there, and the person claiming the amount is not rightly claiming it. If a dispute is just created for the sake of creating it, then that cannot be sustained before the court. So the court has to burden itself with respect to ascertaining whenever there is a issue before it, ascertaining whether it is a valid dispute or not. Yeah, in addition to this, later on, the law with respect to a lot of other aspects to bring out before the court has been clarified. For example, earlier there was a lot of confusion and ambiguity whether an arbitral award passed when the decree holder or the person who is holding that arbitral award, what is his status. So all these things have come to be and there are the law has also evolved with respect to home buyers, decree holders, and every other and all sorts of other creditors. Gradually, as I have already said, and I might continue saying this, that the law with respect to IVC has continued to evolve with time, and whatever was the law yesterday is not a law today. So while arguing, it becomes extremely important for the young counsels here, that young counsels to ensure that they remain updated with the latest position of the apex court, latest position of the appellate tribunal, and that is the National Company Law Appellate Tribunal, and other NCLTs also, because every technicality is being analyzed as due to its ever-changing nature, is being analyzed very carefully by the tribunals before passing their order. And anything which anywhere where the if the application which is made, if it is with a vested interest, or if it is with an intention to defeat the objective of the court, then the tribunal takes a extremely serious view of it, and passes strictures on, also ensures and tries to clarify the law regarding it. So what happened here, the object of the IBC was the effective resolution of the company, and all the and redressing the grievances of all the stakeholders. Usually what happens is that it is always confused to be a recovery mechanism, which it can be at some certain point of time, but it should not be confused with a recovery mechanism, because that is not the end goal of the court. It should be an apparatus which can be used to revamp all the corporates and companies, so that those ailing companies can be effectively resuscitated. So the idea, subsequent to dealing with the admission, as I am also at that point of time, after after a petition is admitted, the corporate insolvency resolution process commences. Subsequent to commencement of the corporate insolvency resolution, if I speak from an advocate's point of view, what happens is that the resolution professional is appointed, and the professional is entrusted with the duty of running the affairs of the company and trying to devise a way to ensure that the company is resuscitated. At that point of time, there are various roadblocks and hurdles that the resolution professional faces, and at that point of time, the role of a lawyer, it becomes extremely important to ensure that they are assisted. So various kinds of applications during the pendency of the CIRP process also emerges, like when if the direct as per the mandate of the court, it is the duty of the erstwhile directors, who are now given the tag of suspended directors of the company which is undergoing the CIRP process, to assist the insolvency resolution process professionally in every manner. If the necessary disclosures which are required to be made to the resolution professional is not made effectively and in a time bound manner, because this entire CIRP process is extremely time bound, so it is important that he has there are provisions in the code which allows him to file an application before the National Company Law Tribunal under section 19(1) and 19(2) of the code. At that point of time, under 19(1) and 19(2) of the code, the as a advocate for the resolution professional, you have to satisfy the honorable tribunal that necessary cooperation is not being provided. So it becomes at that point of time, the law it becomes extremely critical for the lawyer to apprise what all documents have not been provided and how it is affecting the resolution process. So this is also an extremely important part of the entire process. In addition to that, there are various provisions in the code which allow the resolution professionals to effectively combat the undervalued transactions, extortionate transactions, and other kind of transactions which have been made that would adversely affect the interest of all stakeholders of the company. So they are in the chapter, they are clearly specifically enumerated in chapter 3 of the code, and under in exercise of the powers by the resolution professional, he can initiate applications before the honorable tribunal to get an effective order to negate those transactions and bring back the money that was, in other words, looted from the company, if the court is satisfied. So this can swing both ways. It can be filed for a purpose which it was not supposed to be filed. Then if you advocate is representing the suspended directors or other stakeholders, he has to effectively establish his thing. And if he is representing the resolution professional, he has to establish how he has come to the conclusion that these acts have been done which are clearly illegal and detrimental to the interest of the company. So prior to the admission of the CIRP process and post the commencement of CIRP process, a plethora of issues can arise, like in all the big insolvency matters which have been going on right now. For example, ILFS and other ILFS, HDIL, and everywhere. Gradually, as the time elapses and the CIRP process is conducted, a lot of aspects come up, and which in a way expose a lot of issues which needs to be effectively addressed, not only by the honorable tribunal but upon the effective representation of the councils appearing for the concerned parties. So at that point of time, we see that in courts taking different kinds of views with respect to different transactions being done on in with respect to the various steps are taken to protect the interest of all stakeholders. If you see the recent Videocon CIRP process or the ongoing HDIL process, effective steps have been court has endeavored to take upon effective steps to ensure that the stakeholders and companies get their due. So ultimately, whole purpose is to ensure that time-bound resolution is done. All the stake there are recently there has been a lot of criticism with respect to the massive haircuts which are given while in the resolution process. I think recent Harsh Goenka tweet is also something that needs to be very clearly evaluated. So all these things there are existing issues which are affecting the resolution of the companies, but there are other issues also. There are other issues also which now, when we see that the there are when we see that uh, at certain point of time the tribunals are unable to tap the vast number of cases which are coming up. So considering all these things, I think it is necessary that the court needs to evolve continuously. So a court needs to take different views as per the different situations, so that no person can get away by doing an act which is contrary to the objectives of the court. This is in a nutshell some of the things which are there in the IBC thing. And then I think we might get short of time, so I will deal with other aspects of the Companies Act also. Under there are matters which are dealt by the Honorable Tribunal under the Companies Act also. For example, there are matters with respect to operation and mismanagement, where if the minority shareholders of a company are in a manner exploited by the majority shareholders, then they need to file a case before the honorable tribunal and seek effective orders against them if there is any kind of operation or mismanagement by them. Apart from that, there are mergers and acquisition matters, compromise, and so operation mismanagement is under section 241 and 242 of the Companies Act. And other than that, there are another big field and huge number of cases which are being heard by the honorable tribunal are matters related to mergers and acquisitions, where a compromise and arrangement by way of which a company is absorbed or there is a reverse merger are dealt by them. So it is in matters like merger and amalgamation, what happens is that it becomes extremely critical for the advocates to work with the financial advisors, company auditors, and chartered accountants of those companies to ensure that the paperwork is in order, as the legal compliances are extremely important to ensure that the mergers, the company's compromise and arrangement, the scheme that is there is effectively done in a time-bound manner. So that aspect is also becomes extremely necessary in a merger and amalgamation matter. Yeah, apart from that, there are other matters where, like under section 73, if there are 73 prescribes for provisions with respect to acceptance of deposits by a company. So if there is if companies are accepting deposits without complying with the necessary provisions of the Companies Act, then the NCLT can consider those matters and pass effective orders so that the companies can refund back the money from the people from whom they have collected it. So there are various kinds of provisions in the Companies Acts also, which prescribes for prosecution and all prosecution and deposits, merger and amalgamation, registration of shares, and so a variety of matters are being dealt by the National Company Law Tribunal. Earlier, the High Court used to deal with winding up provisions, which was adopted in Chapter 19 of the new Companies Act. But subsequent to IBC coming up, Chapter 19 was repealed and the everything came within IBC. But in spite of that, also all the technicalities with respect to Companies Act is also dealt. So in a way, IBC and Companies Act are the two important laws, and matters pertaining to that are heard in by the Honorable National Company Law Tribunal. One of the aspects with respect to coming back to the topic is that one of the aspects with respect to NCLT is that if during my college days, every book that I have read written by famous lawyers, may it be Soli Sorabji or Fali Nariman, they have always, or in that sense, Kanga, they have always emphasized that there is a huge gestation period for a lawyer when he newly enters practice, because initial years are the time when you do not get any work and you can only concentrate on learning, and only after at least 7 years in practice you start getting work. Thanks to tribunals like National Company Law Tribunal or Securities Appellate Tribunal, that gestation period to some extent has been cut down, because all the established lawyers cannot reach all the courts at one single time. So junior lawyers in a way are getting a very good opportunity to practice in the National Company Law Tribunal, gradually learn the art of drafting, art of making arguments and arguments. So that way gestation period has to some extent come down because of the emergence of different kinds of tribunals. But the thing is that that should not in any manner be considered that a shortcut to excel in the profession. That is my view as far as this is concerned, and it becomes extremely important that wider nitty-gritties are mastered by every young lawyer before becoming comfortable with the tribunal system. Therefore, exposure to all the courts in addition to the National Company Law Tribunal or other tribunals become extremely necessary to gain exposure with respect to all facets of law. Only then can, I think, at the long run, this be beneficial. So, yeah, in a way, I think if somebody is interested in pursuing a career with respect to commercial disputes or commercial laws in any nature, then NCLT is an extremely good tribunal to practice their skills and to establish themselves, and in a manner help in the evolution and betterment of the relatively new laws which are there in this. So these are basic things, I think, which every young practitioner needs to keep in their mind while choosing to practice in National Company Law Tribunal. I think Jay,
Yeah, thank you so much there, Mr. Ranit Basu, for
Jay,
your.
you're not audible, I think.
Hi, can you hear me now?
Yeah.
So thank you so much there, Mr. Ranit Basu, for your valuable insights. I'm sure it will benefit, in fact, not just benefit, but immensely benefit all our viewers who are watching, because most of them are young lawyers, law students who aspire to build a successful litigating career, a successful litigation practice at National Company Law Tribunal. There are so many questions that they are plagued with. How does one build a career? Where does one start? How does one go about it? So what I've done is I've framed a couple of questions, and if you have the time, Mr. Basu, then we can
Yes,
proceed.
yes, definitely. Yes, definitely.
All right. Moving forward, question number one, Mr. Basu, if you could share your experiences before National Company Law Tribunal so far, and what internships or any particular books or any literature for that matter you wish to recommend for a lawyer who wants to specialize in this area of practice before this very tribunal. Over to you.
So, as far as internships are concerned, I think because the CIRP process is something which involves a lot of professionals into this. So, if somebody is looking very keenly on pursuing practice in NCLT, they need to do a wide range of internships. The first one being that they need to intern under a firm or a mid-level advocate or a small setup who are dealing with matters on a daily basis in NCLT. Apart from that, there are big firms like Amarchand or AZB who deal with big CIRP processes. So if an internship is done in that thing, then I think then they will get an holistic exposure to all sorts of matters. In addition to this, I think if somebody is passionate about arguing and making and contributing in the evolution of the law, it becomes important to intern under senior counsels and counsels who are regularly arguing in NCLT, because at certain point of time there are the kind of matters which are being dealt get divided into two types. One being the regular matters which are coming up in regular course, and other matters where the court is seized with a critical question of law which affects the interpretation of the provisions of IBC or provisions of Companies Act. By interning under a senior counsel, they will get an idea of how the provisions are interpreted, and eventually how it contributes in the evolution of the code or the Companies Act. So, in addition to that, they can also intern under an asset reconstruction company, because an asset reconstruction company or a company which is or other similar companies or an NBFC, they deal with a huge quantity of IBC matters, as there is a lot of bad debts that they all have to incur on a daily basis. Depending on the passion, they have these options to go ahead with.
Right. Thank you so much there, Mr. Basu. So, question number two, how different is advocacy before NCLT when you compare it with advocacy before, let's say, Honorable High Court or other judicial forums or quasi judicial authorities? Is it different? Is it the
So,
same? Or, yeah, please go ahead.
no, I think that the procedure for appointment of the members of the National Company Law Tribunal is provided in the Companies Act. So the members who are sitting in the National Company Law Tribunal are National Company Law are extremely qualified in various fields, including litigation as well as finance and everything. So, in a way, the one thing that everybody needs to be extremely clear about is that you have to appear in front of somebody who is an expert in the subject that is being dealt before him. But the thing is that when one appears in NCLT, as I have already said, most of the matters are summary in nature. The court never burdens it, the tribunal never burdens itself with respect to the wider question. It has to deal with they deal with specifics. That is what is the issue with tribunals. So here you do not have the option of making long winding arguments. You have to be extremely particular of making the most impact in the least possible time that is given to you, because unlike in the high courts where you are stipulated a half day or a full day for making comprehensive arguments, here you might not have that liberty, at least in your early days. So it becomes important that when you are appearing in NCLT, at that point of time, the specifics are dealt with effectively. And it may, if in comparison to my experience in the High Court and in NCLT, it might be slightly informal, but you don't slightly informal with respect to the language that is used while making submissions, but specifics need to be the primary focus. And other than that, basic knowledge of commercial laws, basic knowledge of what is a balance sheet, what is how the internal constitutional documents of the companies are there. Those basic knowledges are extremely important to go ahead.
To add to that, Mr. Basu, if you have the time, something that I wish to ask. Uh, when you talk about it, making submissions before, let's say,
Hmm.
NCLT, how different is it? How different is structuring of arguments before NCLT? Do you think the approach is more or less the same, like you do it before Honorable High Court?
See, yeah, I have because I started my career in High Court, and gradually a major portion of my practice involves submitting in the NCLT. I think that because even company secretaries or chartered accountants are allowed to appear in NCLT and make their arguments, their mode and manner or style of making their submissions is not quite similar to the way a counsel will make his arguments. I have tried to adopt whatever I have learned in the High Court to make it there. But what happens is that it has to be much more briefer than when it comes before the High Court, and it has to be how the first thing is that the provisions and its applications. What if I give an example from my thing? I think that the when we argue before the High Court, we first bring out the provisions which are dealing with the issues at hand, and then we show how it is clearly applicable. Here in NCLT, what happens is that you need to show that these provisions are protecting your rights. So the entire ball game changes in that aspect, at least, where you have to impress upon the court that the provision we fall within the four corners of the provision, and by virtue of that we are entitled to the order that we have sought to. But it might be a little difficult for me to give you an exact formula, but I think this is something that is a little bit of a change in NCLT.
Absolutely there. Thank you so much, Mr. Ranit Basu, there for taking out time on a busy working day. And I guess this is what the virtual amicus is all about. Young, dynamic, prolific advocates coming, sharing their experiences. These talks, these experiences in the form of webinars, they go a long way. It is so important when you talk about mentoring and to have a mentor to be guided, because litigation is a marathon. It's not a 100-meter sprint. So you need to be guided at every
Absolutely,
juncture, and when you have
absolutely.
speakers like you, lawyers like you, who are always willing to help young lawyers, grooming them, shaping them, I think that is what makes all the difference. Thank you so much, Mr.
Thank,
Basu.
thank
We
you, Jay.
hope to
Thank
see
you
you
so much
again.
for having me. Thank you.
Stay tuned, everybody. Next episode is on its way. Stay home, stay safe. COVID is still around. It's goodbye for now. Thank you.